So today in this session we are going to learn about you know board of directors. So who is the board of directors? So in this module we'll learn about appointment of directors, managing director, whole-time director, the company secretary, auditors, appointment and remuneration of a manager's personal powers, duties, responsibility, and removal and dismissal, meeting of a board and its powers, company secretary, corporate meeting, types of meeting, annual general meeting, extraordinary meeting, general meeting, quorum, board meetings, and resolution, declarations of dividend, binding up national company law. So this module is again uh, is regarding the functioning of a company. So first chapter is director. Section 149. Section 149 to 172 of the act explains about the director. So director include any person occupying the position of a director by whatever name called, right? So section 149 to 172 of the Companies Act 2013 deals with appointment of directors, their remuneration of director, disqualification of director, vacation of office by the director, etc. So a company is a legal person, right? Living only in the eyes of the law. So it is a creation of law which lacks both body and mind. It cannot act just like a human being. It can act only through some human agency. So directors are those person through whom a company acts and does business. So they are collectively known as a board of directors. They are collectively known as board of directors. So company is the arms and brain. Sorry, directors are the arms and brains uh, through which a company is operating. So company can act only through human agency. So company, so that's why board of director is collectively, the the directors are collectively known as the board of directors. So there is a case called bath, yeah. So bath versus standard land, so that we'll learn. So a board of directors, so who can be a board of director? A company is a legal person living only in the eyes of law. We call it as company is a legal person or separate legal entity, right? Separate legal entity. So so this separate legal entity is a fictitious thing, right? We cannot touch, feel and all. There is no such person, but in the eyes of law, company is a legal person. Company is a legal person. So it's a creation of law, and it can act only through whom? The human agency. So this human agency is called as directors. So the directors are those person through whom a company act and does business. So they are called as collectively called as the board of directors. All right. So in the case Bath versus Standard Land Company, the court observed that the board of directors are the brain and the only brain. The brain and only brain. Okay, of company, which is the body, and the company can does act only through the board of directors. All right, only through the board of directors. Okay, so in this case, Bath versus Standard Land Company, the court held that directors are the brain and the only brain and only brain. All right. So next is a minimum number of directors. So there shall be, in public company there shall be minimum of 3 and max of 7 directors is indeed as per 2013 amendment, and in a private company through 2, and in one person company it is 1 director. All right. So in a public company it is 3 to 7 directors is mandatory, and in a private company it is 2, and one person company it is 1. All right. So by section 149(1) of the Act 2013, every company shall have a board of directors. So section 149(1) of the Act, 149(1) of the Act explains about there shall be a board of directors. So the board of directors shall consist of individuals as the director. Whom? The individuals as the directors. So in the case of a public company, there is a minimum of 3 to 7 directors is indeed needed. In a private company, 2 directors are mandatorily needed. The maximum number of directors in the board is 17. If the company passes a special resolution, there can be a board consisting of more than 7 or 15 directors. So the following company shall appoint at least 1 woman director. Every listed company, every other public company having paid up capital of a 100 crore or turnover of 300 crore rupees or more shall appoint a woman director. Right? Shall appoint a woman director. Is it a gender discrimination? Definitely you can challenge, you can file a writ in the High Court regarding this. Okay. Then so independent director, when we talk about independent director, who can be an independent director? Let's see. Yeah, the minimum number of directors, then we'll go to independent directors and all. So the minimum number of directors for one person company, private company and public company, the minimum number of director is 3 and maximum is 7. The private company it is 2 and a one person company is 1. So who is an independent director? So every listed public company shall have at least 1/3 of the total number of directors as independent director. So every listed public company shall have at least 1/3 of the total number of directors as a independent directors. All right. So you can see in certain cases of companies also shall have at least 2 directors as independent directors. When we had discussed this, right? So the public company having a paid up capital of a 10 crores, a public company having a paid up capital of 10 CR or more, the public company having turnover of 100 crores, the public company having a turnover of 100 CR, right? So the public company which have in aggregate outstanding loans, debentures and deposit exceeding 50 crores. So a public company having outstanding loans, debentures and deposits of more than 50 CR. So every listed company shall have at least one third of total number of independent directors. Out of three, one should be a independent director. Understood? So like if there is 9 directors, definitely um, three directors will be the independent director. So when a public company can have a 2 directors, so the public company having a paid up share capital of 10 crore rupees or more, the public company having turnover of a 100 crore rupees or more, the public companies which have in aggregate outstanding loans, debentures, then what deposits of more than 50 crore rupees shall appoint an independent director. So next is an independent director means a director other than a managing director or a whole time director or a nominee director, which means who is in the opinion of the board is a person of integrity and possesses relevant expertise and experience, who is not a promoter of a company or its holding subsidiary or associated, who was not a promoter. Okay, who was not a promoter of a company or its holding subsidiary or associate company. Then who is not related to promoters or directors of the company, its holding subsidiary or associated company, who has or had no pecuniary relationship with the companies, its holding subsidiary or associated company or their promoters or directors during the 2 immediately preceding financial years or during the current financial year. That is indeed needed. None of his relative has had a pecuniary relationship with the company, its holding subsidiary or associated. It is called as HSA, holding subsidiary and associated company, who holds only less than 2% of total voting power of the company can be an independent director. Less than 2 voting rights, percent of voting rights. So who cannot be an independent director? Who is not a promoter. Independent director was not a promoter at the time of incorporation of a company. Not only that present company, a new company, but if there is any holding company of this present company or a subsidiary company or a associated company, HSA company of the present company which a person is going to join. So that person shall not be a person who is a promoter for whom? HSA companies of this, and who is related to promoters or directors of the company, its holding subsidiary or associated company. So he shall not be associated with the promoter who was in charge with the holding HSA, holding subsidiary and associated company. His relatives shall not have a pecuniary relationship between HSA of this pecuniary company. This particular new company. Okay, if I am I wish to have an independent director of company X, and company X has HSA company like a holding. Maybe sometime it has a holding company, sometime it has an association of a group of companies, or then subsidiary companies are there. Okay, so my relatives were should not have an office of profit with those companies. Okay, not only the present X company but the HSA company of X company. So none of his relatives has or had pecuniary relationship with the company, its holding subsidiary or associated company or the promoters, or who holds or less than 2% of a total voting power of a company can be an independent director. So independent director are appointed from a data bank of person offering to become independent directors. So as I said, there is a association called Indian Director Association. uh, you can also uh, you know take an admission, and there is a course, directors institute India. Let me check. Yes, IOD, Institute of Directors. All right, Institute of Directors. So I'll share that website also. So this is the website. Okay. So if you join here, definitely you can be a independent director after completing their course. All right. This is the website. All right. Okay. So next is a director elected by small shareholders. Director elected by small shareholders. So yeah. So a listed company may have one director elected by small shareholders. A small shareholder means a shareholder holding shares of nominal value of a 20,000 rupees or less in public company. Okay, so there shall be a nominal. Small shareholders are there. Small, we discussed about small shareholders, like ethical practice of a company to preserve small shareholders, which we had discussed. So small shareholders will select a director. Next is appointment of directors. First director. So who is the first director? The first directors are usually named in the articles. Named in the articles. Articles means articles of association. All right. Named in the articles. So that is articles of association. All right. So one second. Yes. Yes. So the articles is articles of association. The first director are not named in the articles. The subscribers of the memorandum shall deemed to be the directors of a company until directors are duly elected by members in the general meeting. So if there is no director mentioned in article of association while incorporation of a company, definitely what happens, the subscribers of the shares, initial subscribers, right, of the memorandum, initial subscribers of the memorandum shall be considered as, deemed to be considered as, okay, directors of the company. Yes, the subscribers of memorandum are the owners of the company or directors of the company, so we can consider it as like that. And at the end of the meeting, general meeting or first general meeting, definitely we can proclaim who is the director. So we can give again, we can alter, amend the articles of association, and we can give it to registrar. So next is appointment of a director by shareholders. So that the directors must be appointed by the shareholders in the general meeting of the company. So that is through, you know, uh, that is not first directors. It is like the second level of selection of directors. All right. So appointment of directors by a board. So before that, I just want to initiate a note, like no person shall be appointed as a director unless has been allotted the director's identification number. So DIN, director's identification number, is indeed needed. It is allotted by central government as well. So an individual intending to be appointed as director shall make an application for allotment of a director identification number to the central government. So within 1 month of application, the central government allows a director identification number to the applicant. So every person proposed to be appointed as a director by the company in general meeting one second, please hold on. Yes. So an individual intending to appointed as director shall make an appointment for allotment of a director identification number to the central government. So within 1 month of application, central government allows a director identification number to the applicant. So every person proposed to be appointed as a director by the company in general meeting shall furnish his director identification number and a declaration that he is not disqualified to become a director under that. So every person appointed as a director shall not act as a director unless he gives his consent to hold the office as a director. He has to subscribe the shares, and such consent has been filed with the registrar within 30 days of its appointment. In the case of a public company, 1/3 of a total number of a director can be given permanent appointment. So the remaining 2/3 are liable to retire by rotation. All right. So this 1/3 will be the owners of the company every time. So every company can adopt by its articles the system of voting. Retirement, retiring director is eligible for re-election also. So that is what exactly, uh, you know mm, appointment of directors by shareholders. Next is appointment of director by the board. So the board of director is empowered to appoint these three categories: additional directors, alternate directors, director filling casual vacancy. So who is additional director? So an additional director may appoint additional, sorry, the directors may appoint additional directors if so authorized by articles of association. So if articles of association, so we will put every loopholes, okay, in articles of association. When we write, when an advocate writes, definitely he will give all the clauses. The directors can appoint additional directors, alternate directors, director filling casual vacancy, everything they will give the clause. So as per the articles of association. Okay. The number of directors and additional directors together must not exceed the maximum limit fixed for the board by the articles. So the additional director shall hold office only up to the date of next annual general meeting. So that is the tenure of additional director. So additional director can be selected with the help of a director in terms of articles of association. So the number of directors and additional directors shall not be exceed maximum limit fixed for the board by the articles of association. And additional directors can hold the office for 1 year, or whichever is earlier, or for the next general meeting, up to general meeting, next general meeting. Next is alternate directors. The board of directors of a company may appoint alternate directors, if so authorized by the articles. So he is appointed to act for a director who will be absent for a period of at least 3 months from the state uh, which meetings of the board are held. So he cannot hold the office for a period longer than the permissible to the original director in whose place he is appointed. So he has to vacate office on the return of original directors. So alternate directors will be appointed by the director itself, and so he can act as a director in 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 the absence of in absentia of the real director, who absent for a period of at least 3 months from the state. State means state, or the country, India. Okay. So his tenure shall not be exceeded. Maybe like the real director's tenure is 10 years. So the alternate director's tenure shall not exceeded uh, beyond the real director's tenure. All right. Next is casual vacancy. So if the office of any director is vacated before the expiry of his term, so the board of directors may fill up the vacancy. So a casual vacancy may occur by reason of death, resignation, insolvency, death, resignation, insolvency, or failure to obtain qualification shares from the office. No qualification shares. So the director also appointed with will hold office till the end of the term of a directors in whose place he is appointed. Next is uh, one more appointment is there, that is appointment of directors by third party. Okay. So the articles of association of a company may give right to debenture holders, financial institutions, or banking companies who have advanced loan to company to appoint their nominees to the board of directors. So like so that is indeed needed. Bankers bankers they will appoint a director. Debenture holders, then financial institutions. So they will appoint a director of their choice, because they have to monitor, right? So the number of directors who appoint should not exceed 1/3 of the total strength of the board. All right. So yes. Next is a disqualification of directors. So when a director can disqualified, what are the incidents? A director can be, say, like terminated or cease operation, you know, from the office. So only an individual can be appointed as a director of a company, because he is the brain and the only brain of the company, right? An individual is disqualified for appointment as a director under this condition: he is of unsound mind. He is not of a sound mind. A person who is a director is not a sound mind. Insanity or lunatic. Insanity, section 84 of IPC. Okay, he is of unsound mind. Undischarged insolvent. Undischarged, so he is a insolvent or bankrupt. A bankrupt cannot be a director, all right. If he has applied to be adjudicated as an insolvent and his application is pending, so maybe the director has filed a petition to make him as a proclaim him as a court has to proclaim this guy. We cannot proclaim, so I cannot as a person like Aravind. So I'm proclaimed that I'm a bankrupt. I cannot proclaim it like that. There is a procedure. Okay, the court can only do that. So a director who is filed adjudication filed a litigation which is in adjudication stage. Adjudication means rectification. Okay, ratification, all right. And his insolvent petition is pending before the honorable court. Then he is a convict or accused as per the court of law of any offense involving moral turpitude. Moral turpitude means, have an example, outraging the modesty of woman. Modesty of woman. Section 476, rape. Then other things like many fraud, mischiefs, anything. So that is called as a moral turpitude. And not only this, outraging the modesty of woman, rape, or any crime which is having a moral. Civil cases are okay, but criminal cases which is having a gravity of a moral turpitude, definitely sentenced to imprisonment of a minimum of 6 months, and a period of 5 years has not elapsed from the date of expiry of the sentence. So if he has been disqualified by an order of court or tribunal on the ground that he is a fraud in promotion, formation, or management of a company. All right. Then what else? One more thing. If one second. Yeah. One more thing is there. If he has not paid any calls of any shares of a company held by him, and 6 months have elapsed from the last day fixed for the payment of the call, he has not taken up the shares, minimum subscription, then also a director can be disqualified. All right. So next topic is, yes, this is what exactly I meant. So the nominal value of qualification share shall not exceed rupees 5,000, or the nominal value of one share where it exceeds 5,000. Okay, so that is what exactly qualification shares. So if the director is not taken the qualification share, this is not mandatory for you to learn, just for the name's sake. The nominal value of the qualification share shall not exceed 5,000, or the nominal value of one share where it exceeds 5,000. So if the nominal value is 5,000, minimum value is 5,000. So if the value of a one share is more than 5,000, that is enough as a qualification shares. Okay. So if he is not taken qualification share, definitely he can be terminated from the office of a profit in a company as a director. All right. So thank you so much. This is the end of today's session. So we learned about what uh, director, who is a director, section 149 to 72. Then board of director. Then we learned a case Bath versus Stand. Minimum number of director. Then independent director. Then you know what are the conditions for a independent director? Appointment of director, first director. Appointment of a director by the shareholders. Appointment of a director by the board. Then appointment of a director by third party like a bank, shareholders, debenture holder and financial institution. Disqualification of a shares, directors because of unsound mind, discharge insolvent, undischarged insolvent, and no application pending before the court as a insolvent. Then convicted for a moral turpitude more than 6 months, and a period of 5 years has not elapsed. So if he is, have an example, he is X have been punished by the court of law in the year of 2019. So he have been undergone through the punishment in 2019 June. Okay, June 2019 for 6 months. June, July, August, September, October, November, December. December he has he have been released. He have been came out from the bars. Then he have to wait for other 5 years to become a director. In between the 5 years from the date of punishment, he cannot he cannot join as a director. Fraud, misrepresentation, promotion, formation. So the court has punished him, disqualified as a director. He cannot be a director. Then minimum shares is needed. So these are the things that we have learned today. So thank you so much, everyone.